Okay, today's podcast on the UPC Insights is about Inventive Step at the UPC, a new approach. Welcome back to the UPC Insights, the podcast where we analyze the latest trends and decisions shaping European patent litigation. I'm your host, George Walden, and I'm glad you could be with us today. Today, we're tackling one of the core concepts in patent law, the inventive step. It's the critical hurdle. Every patent application was clear, but the way this hurdle is approached can vary significantly depending on the forum. Joining me today is my good friend and UPC representative, Tilman Pfrang, who is closely following the case of law of the Unified Patent Court and its approach to inventive step. Tilman, welcome back to the show. As always, great to have you here.
Yeah, thank you, George. Thank you that I can be here.
Definitely. So, first question, setting the stage. Tilman, to start things off, could you give us a brief overview of how the UPC is handling the assessment of inventive step compared to the EPO and the German courts?
As far as we have learned in the past, the approach of, let's say, the German courts and the German Patent Trademark Office and the European Patent Office is different, mostly with the same result, at least I would say, but in conceptually different. Where the EPO clearly favors the so-called problem solution approach. This approach is not accepted by the German national courts. You can try to argue with the problem solution approach, but for example, you will not find it in the decisions then of the Federal Patent Court or the German Supreme Court. And we also regularly hear some criticism from Supreme Court judges or Federal Patent Court judges on that approach. Yeah.
Wow. Okay.
As to the UPC, how is the UPC handling the assessment? Yeah, well, this is interesting, and probably we will elaborate further in this podcast episode on that. The UPC is so far using the problem solution approach. But also some decisions say, no, we do not think it's useful, or we do not have to use it in the present case, and so on. So it's both, I would say.
So both. Okay, setting the stage. Okay, so the problem solution approach, the EPO has long relied on the problem solution approach for assessing inventive step. Can you briefly explain this approach? Is this possible?
I will try my best. The problem solution approach usually starts with comparing the subject matter of the claim, normally claim 1 at the beginning, the subject matter of the claim with the so-called closest prior art. This is a first uniqueness. We are looking for the closest prior art, the most close prior art. And then we look into the differences. Let's say there's one difference, feature A is not disclosed in this closest prior art. And then what we are in a second step looking for is the effects involved in that difference. And here is the first problem. Very often, at least in mechanical cases, there is no clear technical effect. Then it already becomes difficult. Then you must argue, for example, that it's only an arbitrary choice. And then actually at that point, you are more or less out of the problem solution approach. You can still do it, but it does not work very well anymore. But let's assume you have a clear effect. Then the next step would be that you formulate the objective technical problem, which is related to that effect. The second difficulty now we face is that normally it is also, or it may be relevant, that this objective technical problem can also be found in the application documents or in the patent documents. Why is that? Because if you say afterwards, well, I start from the problem so-and-so, it may well be that the other party rightfully argues that the part of the invention actually is the definition of the problem. And since you have not disclosed the problem from the very beginning, you cannot rely on it. So second difficulty with the problem solution approach. And then let's say we can find or we can agree on an objective technical problem. Then the remaining step, would the person skilled in the art faced with this objective technical problem arrive at the claimed subject matter? So that's the last step of a problem solution approach.
So then tell me this, is this approach also used in Germany?
By practitioners, yes. I would say I know a considerable number of colleagues which would regularly use this approach by responding to office actions and during examination, or also I have seen this in opposition proceedings.
Mhm.
Personally, I'm kind of reluctant, and there's one reason. The main reason is the patent office in, let's say, opposition proceedings and the courts in revocation actions. They do not use the problem solution approach, at least not in the EPO style.
Well, then, so does the UPC follow the problem solution approach, or does it develop a different methodology, perhaps more in the line with the German practice?
1 year ago, I would have said it looks very much like the German practice. Maybe two reasons for that. First reason, what you find kind of a mantra in the decisions is words like motivation, incentive,
Mm-hmm.
which you will also find in EPO case law, but which is very important in a German style analysis of inventive step. Secondly, what you can find in early decisions is that they did not use the problem solution approach, and they explicitly said we don't use it. They never said it's unacceptable to use it, but they said in these early decisions, no, we don't think it's mandatory, and we opt to refrain from it. Now, in the last 12 months, the picture is a bit different, starting with, I think, at least as far as I have seen, the Hague division. It was the very famous decision about equivalence patent infringement.
Yeah.
There they bluntly stated, well, we follow the so-called PSA, the problem solution approach. And now, more recently, also the local division in Munich said, well, we think we are a common court to a considerable number of member states. We have harmonized practice by the European Patent Office. And so we think it should be logic and reasonable, or at least sensible, to also follow the problem solution approach. Again, they did not say, but also the EPO doesn't, by the way. The UPC did not say in that case that it's mandatory, but they at least indicated it could be a very good idea to follow the PSA.
So let me ask you this. So you said 1 year ago it was different. It seems to me that the UPC trajectory is it susceptible to trends? You know what I mean? It's like 1 year it's this way, 1 year it's that way because everything is so new. Or what do you think?
Yeah, well, it's developing. This is for sure. This makes it so fascinating for us practitioners.
True.
And this is one very good example where, at least from my perspective, we see a certain shift, or maybe at least consolidation of concepts.
Mm-hmm. But then it's funny you said this makes it very interesting for practitioners. So, or does it make it very frustrating too? I mean, is there a double side to that, or is it just
Yeah, of course, it can be very frustrating. Meissner Bolt, as a law firm, is working on a considerable number of cases, and it regularly happens that you're working on the case, and then you bring your arguments. You think you have now really prepared a brilliant submission and submission draft. You submit the submission, and then 1 week later, there is a new decision, actually stating to the contrary what you have argued before. But you have maybe argued before because there was existing case law. And then 1 week later, the Court of Appeal overrules that case law, and your submission, in a certain sense, is at least in part rubbish. Even if you could not anticipate it, but it's rubbish, it's useless in a certain point, and you cannot do anything about it. But this is normal in our job, but in this density and so often, of course, this is new. Why is it? Because the UPC is new.
Yeah, okay, interesting. But no, I think you answered that very well. So the early UPC decisions on an inventive step, we're already seeing a few UPC decisions touching on inventive step. What trends, as I said before, are emerging, and how do these compare to the EPO's established practice?
The trend, I think, is clearly, or at least from my perspective, that the UPC, local divisions at least, get more and more closer to the EPO practice. For example, what we have not seen as reported is the application of the problem solution approach. Now we see it. Now we see even a guidance from the local division in Munich that it's a good idea to use it. What we don't have so far is many Court of Appeal decisions. There are some, and none of them was using the problem solution approach. I'm very much looking forward whether sooner or later we hear from the Court of Appeal whether the concept of the problem solution approach is a good concept or not so good, or in which situations it might be reasonable or in which not.
What's your feeling? What do you think?
Actually, it might depend a bit on the judges who would decide on that case. I mean, it's not always the same judges at the Court of Appeal, but my feeling is more or less that they are not so happy with the problem solution approach.
Okay. The role of the skilled person, great. A key part of the inventive step analysis is the perspective of the skilled person. Do you see any differences in how the UPC is defining this hypothetical person compared to the EPO or the German courts?
Yeah, I mean, you're right. The person skill in the art is very important, and it's also from practitioner's perspective important to bring your arguments in that regard. However, I don't see a substantial difference actually to EPO German practice. At the UPC, we have seen decisions, for example, where they define the person skill in the art as a team. So this is possible. This is also possible at the EPO. Maybe if there is a difference, and I must be careful in saying that, but I don't see very often in German decisions that they define a team of persons skilled in the art. It is not unknown in German practice, but this is maybe more an idea you find more often at the EPO.
Okay. Well, I mean, the realistic starting point, Tilman, we often hear that the choice of the closest prior art is crucial. How strict is the UPC so far in selecting the most promising starting point? And is there a difference from the EPO practice?
Yeah, there I see a clear difference. At the EPO, actually, you have always, and this is, in my opinion, a huge problem, you actually have to identify the closest prior art. So the idea of EPO practice is there's only one source of prior art, usually a document, sometimes prior use, one source of prior art, which is the closest prior art. And you have to identify this prior art, this closest prior art. I must also add that it is very common and usually accepted that, at least as an auxiliary argument, you submit, well, also document D2 could be considered as closest prior art. So there is some flexibility in the EPO's approach as well. But the degree of flexibility at the UPC and also, by the way, by the German courts it's much higher. The UPC does not even require the definition of the closest prior art.
Okay.
It's just fine if you identify a so-called realistic starting point. And they regularly have said, meanwhile, that there may be several realistic starting points. So the hurdle for this starting, or the definition of the starting point, is much lower. You can always say, in a case where you have a prior art in the same technical field, let's say with a decent number of common features with the invention, this will be accepted as a realistic starting point, but not necessarily as close as prior art by the EPO. And this is a huge difference.
It sounds like it. So then let's move on to the impact of the national case law. Given your experience, do you expect German and other national case law to influence the UPC's approach to inventive step, or is the UPC aiming to set a new standard? That's what I mean. Is it going to be a new trend?
So far, I would say before the first decisions, I was very curious what the answer might be to such a question. But now what we see is actually that the UPC is adopting practice which we have known for a long time from the national courts, from the EPO. I would not even say there's a merger of concepts. I mean, they accept both. They clearly accept, if you argue with the problem solution approach of the EPO, they also clearly accept if you argue in line with national practice. So in the end, I don't see a new concept and not even a merged concept, which is not overly surprising in the end, because I mean, it's about the law. The law says the invention must not be obvious over the prior art for the person skilled in the art. And this is what we have to deal with. And therefore, I mean, it's actually good that they do not come up with a new concept, because that might mean we didn't understand the law in a correct way for many decades now.
So have you had this problem yourself? Have you had this situation where you're completely prepared for something and it just changed? Like you said, your opening statement went out the window or it didn't apply anymore?
I can think of one example, maybe.
Okay,
Let's
that's
say let's say 10, 12 years ago, it was very okay with the European Patent Office if you started from, let's say, several, 5 or 6 so-called closest prior arts.
okay.
And then, I mean, maybe also as a reaction to the abundance of attacks they were faced with, some opposition divisions and also boards of appeal started with being very strict in this regard. Sometimes even so strict that they did not accept any further closest prior art
Wow.
as an attack.
Okay.
And this was at a certain time a bit surprising because there was obviously a change in practice. And now I would say that we are back to normal. Now I think it is an appropriate number of closest prior arts which you can base your attacks on.
So basically, it's got some structure to it then. The strategic takeaways for patentees. Now, this is important. So what practical advice would you give to patentees preparing to defend the inventive step of the patents before the UPC?
Yeah, first of all, I cannot repeat it often enough, you should probably draft your patent applications. One example, I mentioned it at the very beginning.
Mm-hmm.
It is very difficult to argue for inventive step if you have a distinguishing feature over the prior art, and if you did not say anything in the original application documents, what's the purpose of this feature, what's the effect, what's the advantage. The more explanations about effects and advantages you have in the original application documents, the better. Then you can say, well, it's not an arbitrary choice. It's not like we use a screw instead of a nail. We use a screw with a purpose because it has an advantage. And then it's much easier to argue for inventive step. And there's also some head node decisions from the UPC clearly pointing that out.
So just to take away from the patentees, what happens if, I mean, would you advise them if they haven't already done all the homework, like you said, to investigate and come up with good answers as to why this is an approachment on their product? What would you advise them to do? Do they come to you and then you say, no, you need to do this first, and then before you come to me with this problem?
Yeah, a little bit like that. I more or less would say what's done is done. The problem is the following. I'm well aware of case law of the Federal Court of Justice in Germany, so the highest court for patent matters in Germany, saying that, I mean, any advantage you would like to use for an inventive step argument must be in the patent specification.
Mm-hmm.
And from that case law, you could theoretically derive, well, it's okay if it's in the patent specification. And also, such patent specification can be changed during prosecution. So it's basically not, well, very, very difficult to introduce maybe an advantage or effect in the patent specification. However, I'm quite sure that in a concrete case where this advantage is not to be found in the original application documents, also the Federal Court of Justice in Germany would come to another conclusion and either say, we have to clarify ourselves, it must be in the original application papers, or they would say, either it's kind of an inadmissible amendment because you added some information which was not in the application before, or, I mean, we cannot use it. So for inventive step then. So either or, you will not win your case as a patentee. So yeah, short answer, what's done is done. You can try, but you will not substantially improve your situation afterwards with adding advantages, effects, and so on.
Wow, I mean, interesting to know. That's pretty detailed for the patentees, which is, I think, important that they know that. So, well, then good. But Tilman, then I appreciate you taking time out of your busy schedule because I know you've got a lot of cases going on. So that wraps up today's episode of the UPC Insights. Tilman, thank you for joining us and sharing your insights into how the UPC is tackling one of the most fundamental concepts in patent law. To our listeners, thank you for tuning in. If you find this episode helpful, make sure to subscribe share, and leave us a rating. And if there's a topic you'd like us to cover in the future episode, drop us a note via our website. Until then, next time, this is George Walden, and you've been listening to UPC Insights with Tilman Pfrang. Tilman, thank you once again for joining us. And to our listeners, take care and see you next time. Auf Wiedersehen.
Auf Wiedersehen, Charles. See you next time.